Okay, we're live in just a few seconds. Okay, and it looks like we are live. And I'm Tazza Greenwood here at MIT, and I'm speaking in the role as producer of the soon-to-be published MIT Computational Law Report. And this is a podcast, kind of video and audio podcast, to start to explore what we're calling the concept of, quote, legal primitives, end quote. So, what are primitives? Not like cavemen necessarily, but more conceptual primitives, like building blocks of law. In the computational context, we're going to need to be able to, in a modular way, figure out those kind of fundamentals that can be built upon. And this has arisen in part out of a really interesting conversation with our conversant today, Drew Hinks, who himself is has been practicing in the area of cryptography with law, having to do with blockchain, and has got an academic habit that he feeds at New York University. And we had a really interesting conversation about this in a dinner in Chicago recently for the Block Legal Tech Conference. And we want to further explore the concept and also get it out there to get more people's views. And so, Drew, I just wanted to thank you, Drew Hinks, for being willing to play and explore the concept further. As maybe you can introduce yourself so people can know who you are, and then we'll dive right in.
Wonderful, Dazza. Thanks so much. Hi, for everybody who's listening or watching. My name's Andrew Hinkus. Thanks for having me, Dazza.
Hinkus.
Hinkus. Yeah.
Sorry.
That's how my dad says it. It's what happens when a bunch of Russians come through Ellis Island and are given a British name. So they say it Hinks typically, but we say it Hinkus. So thanks so much for having me. As you just sort of were kind enough to mention, we had a great conversation over a dinner at a legal technology conference that was focusing on cryptocurrency blockchain solutions for legal issues. And we talked about this issue of legal primitives, which I'm excited to spend some time speaking with you about today. A little bit of background about me. I have a technical background, having previously worked with databases in computer consulting prior to becoming an attorney. I've practiced both in-house and as a private attorney. I'm currently with a law firm called Carlton Fields, where, as you mentioned, I am working on legal solutions for folks that are using cryptocurrencies and blockchain technology to do various things. I also, as you mentioned, am an adjunct professor at New York University, both in the Stern School of Business and in the at New York University Law School. I'm currently teaching a class called Digital Currency, Blockchains, and the Future of Financial Services. And that's the roundabout way of the different credentials that led me to be at that dinner, where we had a chance to talk about the really interesting, somewhat confusing and emerging area of trying to identify what primitives might exist in the legal system as the predicate toward building technology systems that are able to incorporate the concepts of law with the technology.
Indeed. And so let's dive right in. So as I think I sort of foreshadowed, this way of approaching building blocks is borrowed from or extrapolated from cryptography. And in cryptography, there's this long-standing concept of cryptographic primitives. And just to give a sense of what they are in that context, and see if we can extrapolate it to a legal context, a computational law context. Reading from the Wikipedia page, it says, cryptographic primitives are well-established, low-level cryptographic algorithms that are frequently used to build cryptographic protocols for computer security systems. These routines include, but are not limited to, one-way hash functions. So that would be like the SHA-256 was an example of a one-way hash function, and encryption functions. And the key function that they're referring to there, I think, is digital signatures. So there's some overlap here with legal functionality. And let me just read a little further. When creating cryptographic systems, designers use cryptographic primitives as their most basic building blocks. Because of this, cryptographic primitives are designed to do one very specific task in a precisely defined and highly reliable fashion. And so, so that's sort of the highlights of what we mean by cryptographic primitives. And in cryptography, some examples are, as we already said, the one-way hash function, and digital signatures, something called cryptographically secure pseudo-random number generation, being able to have pseudonymous random numbers generated is a key underlying function and sort of like input to a lot of other cryptographic systems. And there's others as well. The very concept of dual key cryptography, the basic algorithm that results in having a public key and a private key is thought to be a cryptographic primitive. Kind of conversely, so is symmetric key cryptography, when you just have that one key to encrypt and decrypt things. So that's sort of the best of cryptographic primitives, and it raises the question, as the law transitions to occurring online, just like every other sector of the economy is been digitized and now is addressed through web browsers and applications and network services. And the law is beginning to transition that way. From almost like an engineering or architectural perspectives, what might the legal primitives be that would underlie these more complex combinations of functions that, whereby people do contracts? That's includes signatures usually, the terms. There may be other types of features or other complex instruments, like a derivative has a lot going on. There is math involved. Notice is one that comes up in my mind, is something that's like a building block that drives a lot of processes, or it's a key kind of junction in a lot of legal processes. So what do you think, Drew? Like, just kind of conceptually, sitting in your ivory tower for the moment, looking down upon the world as it is and as it could be, what might legal primitives be?
So the first issue that comes to mind is one of scoping and of ranging. Mm-hmm. In trying to figure out what the basic building blocks of a legal system would be, you have to think about what you start from the context of what you know and understand. I'm American, I come from the Western legal tradition, and law is not homogeneous around the world, and it has not been consistent over time. It, like everything else in human society, has developed. And so one way to think about identifying primitives in the law is to think about those base building blocks or commonalities across legal systems. Many of the things that you shouted out, notice and signature and the idea of enforceability and dispute resolution, all are common but distinguishable across different cultures. We might have notice being required in certain instances under X nation's justice system, but not under others. But there is the concept of notice as a predicate to taking some action against somebody that's essentially either absent expressly or implied or provided in various legal systems. And so by looking at the things that are modulated, when you compare legal systems, you can see the things that are common across them, whether they're done in a consistent way, whether they're used in some places and not used in some places. They seem to be persistent issues. And so I tend to take these very close to the ground, so to speak, when I think about them. One that I think is very important is the idea of the governed and the governors. Law is a system that is based upon abstraction. It is abstracting the nature of relationships among people, and in systems that recognize it, among people and property. There are some legal systems that have never really acknowledged property rights. There are some legal systems that have found certain human lives to have different value than others. And although some systems don't acknowledge these property rights or personhood, they have some measure of property rights and personhood. So those would be two places that I would start. And to communicate what rights attach to legally identifiable actors and legally identifiable property, there needs to be the ability to communicate between the governed and the governors. So those would be three places that I would start when establishing very basic legal primitives. If that's too close to the ground, then we can move up a level.
Well, let me take a note here. We have a shared hackpad document between us, so I'm adding on line 59, ability to communicate between them, because that's beyond what we said last time. And that does make a lot of sense. Maybe notice is part of that, potentially. So I don't think that's too close to the ground. I think that's an awesome start. And that's partly what I was hoping to elicit from you as we got into this conversation. So let me throw a few out as well, just to seed the dialogue. I'd mentioned notice. Excuse me, I'd mentioned signature, and I think that might break down to a few flavors, at least one of which bears directly on this relationship between governed and governors. So there's assent, that's really a contractual concept under the common law. Like a signature would be a way to express assent to be contractually bound. There's other ways to express that assent. The concept of authorization, signing something to authorize someone or to delegate, and the concept of consent, such as like a consent to a medical procedure. That's not a contract. And there's other dimensions of consent that we under the is it the Hague Convention? But basically, under like kind of post-World War II national conventions, we may require that the consent be informed, that the person understood the terms, that there'd been nothing coercive, or they'd be under no pressure whatsoever, at an even higher degree of scrutiny than just assent to like terms and conditions on a click-through contract, for example. So when you get to consent, I start thinking about one key application in a jurisprudential way and in terms of the social compact, consent to be governed. That's really what, in the US at least, conceptually, the whole legitimacy of our government is founded upon an act of consent by at population scale to be governed. And we had ways to express account for that centuries ago in an agrarian society. Now comes the digital information society. How would you express consent now, and what would that look like if you imagined like we're starting the country again? What would be the legal primitive, the basic functionality that what act would they take to express consent?
So if you think about the founding of the United States, the founders broke off from the British and established a fundamentally different basis for the government. The British, like most monarchies, founded their legal theory on all power flows from the crown. In our government, the theory is that all power starts with the people, and there is a delegation of power to the states to govern those people, and there is a limited delegation of power from the states to the federal government to exert power across the multiple states and the people.
Right. So
you have an inversion.
Check out the 12th Amendment for those that want to go deeper into how we've ultimately written that concept up, right?
To a certain extent, it's captured in the 12th Amendment, but if you go back and look at the founders, there's some considerable discussion about the source of power to govern. And the United States is based on the grant of power, where power resides with the people, as opposed to power residing with the crown, where really, if you trace it back through its lineage, the crown was more or less coextensive with a god or a religious grant. And so perhaps one primitive to think about is the source of the power. And while the source of power may or may not be relevant to those who are trying to, understand what their rights are to engage in a certain set of conduct, it may be useful when trying to determine where the tie goes in case of the ball getting to first base at the same time the foot hits the bag. Use a very clumsy sports metaphor.
I just added to the top of a little working list up on line 33, authority, and including the source of authority. And, it reminds me of a bunch of federal work I'd done, I don't know, more than a decade ago, where very frequently an agency, before creating a new system, like I'd worked on identity federation systems for like GSA and other agencies to do their purchasing and enable citizen participation in processes. The beginning of every, kind of formal, well, whether it was an NPRM or something in the Federal Register, or actually launching a system like that, was always the express authority by which that agency had the power to take this action. And there was a little bit of CYA there, but it's also fundamentally basic civics, that we don't have a limitless remit of power from, for the emperor from God, or the warlord based on how many, what the strength and deployment of their militia is. What we have is limited powers that, as you say, derive from the people, and and it's not just a theory; it's expressed every day. So moving on, I'll just do kind of I'll skip across the top of the waves of some of these things just to maybe get some more ideas flowing. Authority, we said signature, notice, maybe a rule, like could just like generically the expression of a rule be a primitive? Could a right or conversely a responsibility, could those be primitives potentially?
So when you get into rights and responsibilities and benefits and burdens, you're sort of creeping toward the idea of contracts, which are agreements whereby people, depending on what your philosophical bent is, either agree to do things for each other because there's a perception that it benefits one or the other, or whether they agree to bind themselves to each other for whatever their reason is. And when you get into the realm of contract, you really are talking about the ability to use magic words.
Could you just unpack that a little? I think I know what you're referring to, but for everybody's sake, what do you mean by magic words?
Sure. I can say in the United States virtually anything that I want within limitations. The government doesn't restrain my ability to speak. We have a unique set of rights in this country. The words that I say, however, are limited to a certain extent. In the private context, they're more limited than the context of what the government can prevent me from saying. When I use magic words,
I'm sorry, just before we go further, you mean in the private context, it's less limited than what the government can prevent you from saying?
The government has fewer grounds to prevent me from saying things than perhaps a private party. This goes into the often misunderstood First Amendment argument that I can say whatever I want, you can't stop me. Well, the government has, we have the First Amendment, which says that you have freedom of speech. Doesn't mean it's unlimited, but you have freedom of speech. The whole shouting fire in a crowded theater, you can prescribe that. The time, place, and manner of communication, and so on. From a private standpoint, you have less or fewer rights. If a journalist doesn't want you to publish certain things in their newspaper, they can say, too bad, I'm not going to run it. Doesn't prevent you from speaking it, but they don't have to host your content. That's really a bad example because it gets into CDA 230 stuff. So I'll
right, but I guess you can take it that in the private sector, there are rules like libel and slander, and a few others, intentional interference with beneficial contractual relationships, and you can think of a few others, intimidation in certain contexts, as is playing out in the press.
I'll pay you to kill my wife thing. That's a crime.
That would be bad. It sounds like a quid pro quo.
If you're listening at home, sweetie, I don't want to kill you, I promise.
Yep. And it turns out turns out all of these things are restrictions. And in the public sector context, I'm pretty sure basically all the private sector restrictions apply, but then there's another layer for freedom of political speech and a whole bunch of other stuff, so the public sector is further constrained, I think is what you're saying. And how does this play into the idea of when there's a right, which maybe not contractual, like a human right, a civil right, civil liberty, or a contract right? Would it make, if those were, or at least some of those were able to be, I don't know, almost encapsulated and expressed as a right, wouldn't it be convenient to be able to, identify them and almost sort of like collect them in the appropriate clauses of a legal instrument or even a statute or regulation, and therefore be able to, get maybe easier to identify and to track them and to see when they apply and to whom they apply? And wouldn't that make things easier?
So if you want to give people the freedom to bind themselves to each other, and if you want those decisions to bind people to be enforceable, then you need a few things in place. You need to be able to identify what the agreement is. You need to potentially create a system where there are consequences for not fulfilling the agreement. To create the agreement, we need to have a way of understanding each other. And that's where I was going with the magic words, because the magic words are the things that take communication and turn them into something that's binding and enforceable. And so language, the ability to actually communicate with each other, is probably a primitive on some level. I'm not sure if I'm too high or too low. And then the ability to take words and ascribe meaning to them and to make them enforceable is another potential way to think about building out a justice system or a legal system.
That's fascinating. So one of the people at our conference and who we sometimes collaborate with is Henning Dietrich. He has the Lexon system, where in English, at least, perhaps German as well, his native tongue, I think, he's got the system where you can write through a constrained subset of English of words, English words, like a clause to a contract, for example, and that will, you identify certain kind of contingencies and variables, and then on the right side of the screen, like a split screen, almost magically, what appears is blocks of code. In Solidity or Sophia, we're working now on a JavaScript implementation, and so, in fact, that does completely assume and even code without the English language kind of almost quasi-compiler also is not language agnostic. There is a language, and so to really understand it and to parse it, one would have to have access to the vocabulary and the grammar to some extent, and the syntax, because that's necessary in order to run the process. And so it does raise a question. And then when you get to law, all the more so. It's the ocean within which law swims, is language. It raises an interesting question: to what extent is or should that be true as we move into the computational law era? Just as a data point, I'm thinking of work that I collaborated on with the SEC, where they created a schema, an XML schema, for publicly traded companies to do their quarterly filings. So they up to that point in history, it had always been in either a paper, like a PDF, like a narrative form.
Right.
And tables are involved, obviously, in financial things, but it's all written in English in this case. And that created issues. Like for Enron is like the classic example where there was kind of disclosure, but it was buried in these footnotes that referred to other things. And you'd have to have a team of forensic scientists to parse everything to have discovered later that they sort of disclosed the shell games and other things that they had done. If this was all done in a standard computational framework, it would be possible to kind of sort, filter, search, and do analytics and very quickly see more accurately what's going on for enforcers, but also for investors and everyone else. So anyway, they adopted this dialective XML called extensible business reporting language, which is a darling of the accounting and audit industries, and it provides a standard way to mark up and to kind of code computationally all of the a basic accounting, and then they extended it a little bit so that it would be suitable for SEC filings, and they made a rule that enabled that defined and specified how you would apply this programming dialect, basically this structured data dialect, to for a company to provide its required filings and disclosures. So the interesting part is there was a debate toward the end when they were looking to implement this, which is when the company provides the PDF with a narrative along with the basically the markup kind of data. If there's a different potential interpretation, or if there's an actual conflict between the two, which one is authoritative? Like,
I love that.
which one will we hold the company to? And after much debate, the decision was we're going to hold them to what the data says. You know, there's a lot of the whole issue, and the whole reason we're doing this is there's ambiguity that can be really counterproductive in these disclosures that are supposed to put people on notice and provide a reliable basis for making decisions with this English narrative form. And they wanted to limit that and make it more objective and accessible and kind of processable, computational, if you will, with the data. And so I wonder if that might not be part of how the law evolves more generally to be computational, and what that would mean for the place of language as being a primitive.
So this conflict between attempting to structure information in a way where it's more processable versus native language, this conflict and this issue of if you're requiring people to file in parallel English language paper along with data and there are contradictions or confusion, which one should govern, this is an issue that still pops up, and it pops up in a bunch of places. In my crypto world, there was this effort to create a system called the DAO, which was supposed to be a decentralized investment trust. And there was a category of actor within that structure called a curator. And part of what the curator was supposed to do was to reconcile the English language description of the potential investment opportunity with the code segment that was supposed to plug into that venture to ensure that the code was going to do the same thing that the English language was describing it would do. And as you might imagine, there are tremendous governance issues, tremendous liability issues in delegating that to a person and saying, here, group of people, you have this responsibility. We also see this issue come up in the prospect of we're going from a specific instance to a sort of broader instance in technology referred to as smart contracts, which you can think of as kind of automated transfer or programmable money is probably the simplest way of explaining what a smart contract can be. And Professor Grimmelman from Cornell wrote a wonderful, very short, very readable paper entitled All Smart Contracts Are Ambiguous, which talks about the different layers in a smart contract where commercial parties using them or parties using them may be able to manifest what their intention is and what the terms of their agreement are. And that it might be outside of the smart contract, it might be the smart contract code. There could be ambiguity in how the smart contract code compiles into the actual code that is executed by the machine. I don't want to do his paper a disservice by giving such a cursory summary of it. It's really rather good. It's really rather readable. It's really rather short. This little codicil, or this little, cul-de-sac of our discussion is interesting. I encourage anybody to go read it. I think it's only like 22 pages long.
Okay, could you on Telegram or somehow shoot me a link to that, and let me endeavor to get that into the show notes so people can kind of click along. And I should very much like to refresh my memory on that as well. So let's move on. So something that you and I kind of hack on a great deal in different groups, and you mentioned a little bit or foreshadowed it with this concept of DAO, which, by the way, for those that may not be familiar, is DAO, and it's an acronym for Distributed Autonomous Organization. Decentralized, excuse me. Sorry, I was just looking at your Telegram feed with the link. Thanks for sending that. A little distracted. Decentralized. And and that really gets us into this conversation it's one of the themes for the first issue of the computational law report, which is legal entity status. In this context, the question is, well, is this DAO a legal entity? Does it have the properties of a legal entity? Could it agree to a contract? Could it sue and be sued? That sort of thing. Does it have limited liability, or how does liability even play out in this context? And of course, the question arises increasingly now is companies and firms generally are themselves just composed of sets of software, the HR software, the marketing software, the accounting software, the meeting software, the corporate governance software, the contract software. The firm is software. And how do we start to conceive of the membrane around the software, the enterprise, as a legal entity? Could part of the software be to form the corporation, through a web process and to maintain it? That might be a good idea. It's one of the projects that we're working on. So, but the underlying question here is entity, or legal entity, could that or should that be a primitive in computational law? What do you think?
I think that's a good one to look at. I believe that most legal systems make distinctions between things that have legal personhood and do not. In the context of the DAO, for instance, there was the question of what is that thing? Now, most collective actors take advantage of rights provided typically by some sort of statutory enactment that allow people to incorporate or to register their collective action as a business entity that's given certain powers and rights and also burdens and responsibilities by the law. In the olden days, you had individuals who were responsible to the law and who had personhood. And then there was a limited bequest of power by the crown to act together in a way that would allow you to have independent legal existence from your personhood. And they were called charters under the British, under the British means of conduct. And so under British law, you would apply to the Queen or to the King or to the Crown for a charter. And it was basically an exception that they would say, okay, you can do these things collectively, and the Crown will view you as this independent legal actor instead of as you people acting together. And the consequence was individuals didn't have liability subject to certain parameters for their conduct. The conduct was ascribed to the entity. And so over time, this went from being a series of one-offs to things that were eventually codified. But the basic structure was sort of the same. You're an individual acting unless or until you apply for a special dispensation to act through an entity. Nowadays, it's relatively simple. You fill out some paper, you pay a fee, you send it to the right person in the state government, or in limited instances, federal government. You wait a little bit and you get a piece of paper that says, congratulations, you now have a legal entity through which the following persons are authorized to act. And it's still something of a trade-off. You have to give information to the state. You have to tell them who you are. You have to tell them how to find you. You have to designate a person to receive service. You have to agree to pay taxes. You have to agree to share certain information. You have to agree to limit your conduct. If you violate the rules and you do things you're not supposed to do, you can still be held individually liable. There's this concept of being able to pierce the corporate veil, which is a way of getting to the individual actors using the corporate form if they misuse it. And almost every state has a case that talks about under what circumstances you can pierce the corporate veil to get to the individuals. Now, there are a variety of different entity types that are available, from corporate, which are basically corporations and derivations therefrom, and non-corporate entities, including things like limited liability entities, and they vary from state to state. The most commonly used one in the United States is the Delaware entities. They're very popular for fundraising, and they provide a lot of protections for the individuals that are operating them, so they're very popular for businesses. However, these DAOs, certain of them have chosen to completely ignore the concept of incorporating in a jurisdiction or registering in a jurisdiction, and instead deciding to proceed as if they are illegal, meaning that they are not participating in the legal system altogether. And that is a dangerous game to play, because while you may decide privately that you are outside of the justice system, it does not mean that everybody will always decide to stay out of the justice system. You can decide, for instance, that you want to not have the legal system apply, but it does not mean that the legal system won't decide to apply to you anyway. And the perfect example of this is the limitation on contract law. For instance, Daza, you and I can agree that if I don't drink coffee for a week, you're going to pay me $10, right? I can give up that right in exchange for payment, no problem. But that doesn't mean that you and I can agree that a 12-year-old, let's say I have a 12-year-old son, that my 12-year-old son can drive a car. The state of Florida requires you to be 18, I believe, and by private contract, we can't waive that. Similarly, we can't waive securities laws. Similarly, I can't decide between me and a owner of a building down the street that we're going to demolish the building on Tuesday at 11 o'clock. We can't opt out of local ordinances that exist for life safety and so on and so forth. And so the risk in proceeding under an unregulated entity like a DAO, proceeding on an entity like a DAO without incorporating is that even if you decide you don't want to have a corporate form, the law can decide to impose a corporate form upon you. And so a judge may look at an unincorporated DAO and say, well, really, you look like an unincorporated association, and here are the rules according to our legal system as to how to handle you. You might be a general partnership, and here are the rules that we use to govern the conduct of general partnerships. It might be a joint venture, and so on and so forth. It could be one of the weird little historical one-offs that we've allowed to continue, like underwriting syndicates and like Lloyd's of London, where they're allowed to proceed in this sort of quasi-entity form. And so I think that by talking about the exceptions, we're able to sort of better understand the parameters of the rule, which is there are a bunch of weird consequences to acting collectively without taking advantage of the ability to be recognized independently as an entity instead of through actors. And this illustrates the fact that legal systems presume that there will be recognition of legal personhood, whether it's as a collective synthetic entity like a corporation or a limited liability partnership, or as humans. And again, going back to what I said at the beginning of our talk, not all human lives have always been deemed to be the same under law. There have always been some recognition of human lives, and there has always been some recognition of certain types of property. And so I think those are important primitives to start with as well.
I'm going to add property here. Property. There we go. On what is this? Line 42. Life, the universe, everything, and property. Line 42. So, staying in the DAO context for the moment, but I think it's maybe applies equally for more mundane systems, other software systems, things in the cloud. To the extent an entity of some type, say two or more people doing collaborating for a common purpose, is formed by software, and it's happening already. But as we look into the future, will be more and more common and perhaps more standard. Perhaps having a kind of a well-specified and common and reusable primitive that indicates legal personhood and a legal entity status of some type that was, that maybe we could have some properties. Maybe one of the specifications is that it indicates what jurisdiction was it formed in, and what type of entity is it, corporation or LLC or something else. Where do you find the person for service of process, maybe some contact info. If you look at the Google Business Directory, like they've got a pretty solid common set of metadata, if you will, around entities that have, and there's state business registries, but you could imagine a kind of extracting a subset of common properties that you could wrap together in something like a legal primitive that we could, in the fullness of time, call legal entity status.
Yeah, I think recognition of something as a legal actor is a very important primitive. And so I could call that legal personhood or legal entity status,
Hmm.
right? And we've seen this develop over time as intellectual property became a recognized right, as people have received additional rights that are tied to their legal entity status. Think about rights of publicity and rights of privacy. These are additional rights that have been defined over time, but they remain a function of the person,
Indeed.
right?
And I'm thinking back to a multi-stakeholder rule-setting process of 5 or 8 years ago, where there's a big identity federation effort with the then Obama administration and a bunch of private sector actors and civil society groups to come up with a standard for federating ID.
Mhm.
And um, there was some definitions, and one of them was human entity, non-human legal entity for like
Okay.
corporations, and then non-human, I think it was like non-legal entity. So it was like human legal entity, non-human legal entity, and just like a non-legal entity. I'm
What were
riffing a
those?
little bit.
What fell into that last category?
And this is a lot of people that were there were technical, and
Mhm.
it was very helpful for them to talk about entities that exist in a network. So a router is very much an entity. An endpoint they think of as an entity, and
Okay.
we were spent honestly like months talking past one another in drafts because of the basic confusion of this distinction between what entity means in technology context versus legal context, where we parse other aspects. We ended up defining that something along the lines of what I just said. So I very much like, that's all by way of saying, I really like your friendly amendment to this like kind of rough set of notes. So I added the word legal before entity accordingly. Let's do one more and
Okay.
then wrap up. Okay, this is since you're kind enough to join us in your very limited time, would you rather do dispute resolution, which to me seems quite big, or maybe, and here's one that's coming up for as we're launching this publication, MIT Computational Law Report, citation. We're like, ooh, how do we do a citation that's like a lot more, that's really born digital, that has a sense of a link in it? Like the blue book citation format is not really what we're trying to do. Is there a citation primitive to refer to law and to cross reference things? So what do you
I
prefer?
think you need to go deeper on citation
Okay,
because
let's do
citation.
citation then. And what are your
So,
thoughts on it?
sure. So citations are only relevant if past decisions mean anything.
So that would be if we're setting a precedent.
Right, because citation suggests that there's some value in comparing an outcome to a prior outcome.
Well, may I offer another way in which it's used functionally? So
Uh-huh.
when I had been doing legal practice, now when I'm doing sort of business consulting, combined business legal technology architecture kind of practice, very frequently we'll separate parts of a system's rules and components into different like documents and
Okay.
or other files, and then we'll incorporate them by reference. So
Okay.
maybe like the participation agreement for some trading network is this file, and it may change at a different rate from the community umbrella rules. And then there's another file that's absolutely essential, like a metadata exchange file when you're connecting to the
You're talking
system.
about referring libraries referring to each other more so than you are case precedent.
Exactly. And so we still consider it a citation, and it's formal, and we need to know how to do it. So, it's, and we say it's a citation, and we're citing to another instrument or contract or rule set or something that's incorporated by reference. So that would be another way in which citation is used, but it's not for the purpose of precedent, I wouldn't say, not primarily at least.
Okay, so we can leave that aside. So citation in your, so I'm wearing my lawyer hat for the moment,
Good,
thinking about legal
please.
systems for the moment. And in the legal world, citation is looking at another reference point in order to either illustrate a concept, rely upon something else in guiding an analysis, or to explain the reason for a thing occurring.
Yeah, and may I offer also to cite to a statute. So we're doing something like we talked at the top of the show about, what is your authorization? So in some of these big federal documents, if they say, I'm XY, I'm Acme agency, and I'm,
Right.
putting this system out under authorization of like US code, section 5, subsection B or whatever,
Sure.
that's a citation to a statute
Right.
for the purpose of, in that case, it's basically disclosing and acting under authority of a statute.
Right. Totally. So if that's the sort, so it seems as though you're blending together the technical and the legal and trying to figure out if there is some sort of universal, I can look over here for justification for what I'm doing there.
Yeah, that's the question of whether a citation should even make it onto a list of candidates to talk about for a legal primitive. And if so, maybe the idea would be that there's a format and that there's, certain, that it's somewhat standard. And when you're using citations at all, or maybe just in some contexts, like citing to a case or citing to another document, that you can utilize this format, and then you would kind of parse the same way people could, whenever they cite, do the same thing. And it might really let us have more common design patterns and approaches, better interoperability, and sort of like in cryptographic primitives, we don't want to reinvent the wheel every time we do everything. Are there reliable ways that we can encapsulate some of these core kind of functions and components that are reusable? And it's kind of a question. Sites come up all the time in so many aspects and facets of law. Would that be a good candidate for a primitive? Don't know. What do you think?
Yeah, so it seems as though, yes, citation to authority, citation to prior authority, citation to the source of a power is something that occurs frequently in legal systems, whether it's God made me the king, and so therefore I decided that everyone's going to tell me the sky is green today, or whether it's you have the power to request that this purchase order be fulfilled under this enabling statute, or I have the right to arrest you and deprive you of your freedom based upon this law that says that murder is a first-degree felony in the state of Florida. So it is potentially a piece of the connective tissue that holds together the skeleton of a legal system. And I don't know whether that fulfills or qualifies as a primitive or not, but that's the way that I view it. And I feel like the bones would be things like personhood, rights, the ability to have orderly, or at least to have some form of dispute resolution, the ability to enter into private agreements that are enforceable, things like that.
I've just sent you a reference to it on line 46. I just, after adjudication, just kind of clarified that to be dispute resolution. Maybe that's the correct wrapper for that. Okay, so what I'm kind of getting out of this is maybe not cite, maybe citation is a different type of functionality that's more like, I don't know, the blood flowing through a system, or something that isn't like a component, like a bone that would make a skeleton, perhaps. So I don't actually have a strong opinion about this, but I know it comes up, and so I thought maybe we'd just chat about it. So looking forward, there is another person who wasn't able to join us today. His name is Christian Smith of the very interesting startup Stranger Labs that is putting together some interesting, including cryptographic systems, so that you can know when you might be able to trust a stranger, thanks to, using cryptography and a layer of law. And he has some, more from a hardcore crypto perspective, some more ideas and his own perspective on what legal primitives could be. And I think what we're going to do is a sort of part 2 of the Legal Primitives podcast, where we get Christian into the mix to find out some of his thoughts. He's finishing kind of a business deal this week and couldn't join us, but we'll look to get him on the roster soon. And then what we'd like to do is release this as part of the first public launch of MIT Computational Law Report on December 6th. And so I want to thank you a lot, Drew, for being willing to come in and sort of in a very public way brainstorm. And I think it's really critical for people to be able to do this at this point in history, especially, and to invite, as I want to do now, more people to contribute ideas and to catalyze further discussion around this topic. I don't think it's the last time that we'll be talking about this, as more and more of the law is codified as a computational system. So, Drew, thank you for legal hacking with us today.
Thank you so much, Daza, and feel free to call me if you think I can be helpful. Excited to see where the project goes.
You're always welcome here, Drew.
Thanks so much.
Until next time, Daza Greenwood signing off.